At Kampen Law, we have a mantra, which is that losing is not an option. Our clients come to us, often after an abrupt termination that they weren't expecting, and all of a sudden their income is turned off, and they need help, and eventually it becomes desperate help. And I think we need to embrace that desperation, and we do. That we need to win for our clients, and that losing is not an option. But we couple that with determination and grit. To me, I'm not quite sure where it comes from, but I just am a scrapper, and the lawyers that I've hired are scrappers too, and we're determined to win, and that means working long hours a lot of times, but it's what we do. But with grit and determination, matched with talent and desperation, I think greatness can come in legal advocacy. But what is a win for our clients? Start with the reality that of all the lawsuits that are filed in court, only 5% actually end up in a jury trial. So what happens to the other 95%? In those cases, the overwhelming majority either settle or they're dismissed. And so if you look at it as a boxing match, we're not trying to get to the 12th round for our clients. We're trying to get a technical knockout or a knockout in an earlier round and get the employer defeated and beleaguered so that they want to settle with our clients, that we don't have to get all the way to a jury trial. So how do we do that? I think there are 4 core pillars. The first is make your first punch your best punch, and I'm referring to the lawsuit that's filed. So in North Carolina, there's something called the notice pleading rule, and so technically you don't have to write an opus of a lawsuit and make your argument from A to Z. You can just put the employer on notice of your claims. We just turn that rule on its head. We write a lawsuit, it takes a long time. I've spent a week writing a complaint before. But the idea is we want to make an impression with that complaint to 2 audiences. First is the judge. So the judge is going to read this complaint, and he gets a lot of complaints on his desk and has to understand that a complaint from our firm is different and that our client's situation is different. And the second audience is the CEO of the company or the general counsel. They need to read this complaint and be worried. And so I've had management side attorneys in town tell us that they recognize our lawsuits before they see that we've signed it on the last page by our introductions. And so we take the time early on to get to know our client and to develop the theme of our case. And our introductions to complaints read like opening statements to juries. It takes longer to write that way, but they need to understand, the employer, CEO, the general counsel, how compelling our client's story can be told. Number 2 is be relentless. So after a complaint is filed, we go through something called the discovery phase. And returning back to the boxing situation, the employer has to know that there is nowhere in that ring that they can hide. And they will hide things. So we assume that employers are going to lie, cheat, and steal to beat our clients. And that a lot of times involves hiding documents. So we have to be really deliberate in how we draft our discovery requests so that we don't leave them any wiggle room to get out of. We have to distrust them right out of Jump Street, and then we need to go to court. So they are going to play games, and inevitably we're going to have to ask the judge to order the employer to turn over records, and we know that a judge's order will get them to play fair, even if they won't do that right out of the gates. The third pillar is winning the depositions. So after this written discovery phase where we've obtained all these documents, we are going to subpoena to depositions at least 6, 7, 8 people from the company where we can ask them questions. And in my opinion, cases and even trials are won not in courtrooms, they're won in conference rooms and when depositions are conducted. And so we are extremely deliberative heading into our depositions. I love walking into a conference room with my notebooks. So you have a management, decision maker who's worried about what I'm going to ask him. And walking into the conference room with 2 meticulous notebooks that my team have put together 150 exhibits. We know where every one of them are. They start to worry about what emails you have, and they tend to tell the truth for a change when they see those notebooks. Now, we love taking depositions of the managers that are involved in our client's story, but guess what? Our client also gets to be deposed as well. And we also have a lot of fun preparing our clients. So our management attorney colleagues, they ask the same question in every case. They're pretty predictable. And so we really know what's coming with our clients when they're going to be deposed. And I try to get to my client to a point of comfort where they actually start to have fun answering questions. And they're not always fun, but for a lot of my clients, they actually feel really good when their deposition is over. But we pride ourselves also on how we prepare our clients for their depositions. The fourth pillar I call crushing summary judgment. So understand that the company's hope during this entire process is to get your case dismissed before it ever gets to a jury box. And they do that by asking the judge to dismiss it at summary judgment. And so they are holding out hope that the judge is going to let them off the hook at the summary judgment phase. And so we need to crush the employer when they attempt to move for summary judgment. And I'm really proud of the track record that my firm has had. I used to brag that we've never lost a summary judgment motion, and we finally lost one. So I was shocked. It was like a shock to my system, but nonetheless, we do a good job in discovery and really know where the employer is coming on summary judgment, and certainly the exception where we have one of our lawsuits dismissed at summary judgment. And if we can just get past that, 9 out of 10 employers do not want to go through a trial. And it's why we fight so hard to get through summary judgment. And so we may be at that point in around the 10th round, but the overwhelming majority of employers will throw in the towel at that point before we get to a jury trial. Now, worst case scenario, we have to go all the way to a jury trial. By that point, we've defeated summary judgment, and the employer should be beleaguered, and we should be in control. With the documents that we've obtained, with the admissions that we've secured in the depositions, we have a lot of evidence locked in, and we have the advantage of actually conducting what's called a mock trial. So who would want to go into a trial without at least conducting a mock trial in advance to test out some of your theories? And so in a lot of our cases, we'll take the time to conduct a mock trial, hire some mock jurors, and even put our own client through the paces of cross-examination in front of a mock jury to learn where we can get stronger. The other advantage that we have at trial is we get to go first. We give the first opening statement. That'll be the first thing that the jury hears about the case. And we also get to put on witnesses first. And and we're pretty aggressive in how we call witnesses in what's called our case in chief. So, of course, the employer wants to introduce witnesses in the way that they want to, in a very scripted way. And we can completely take them out of that strategy by calling some of the management witnesses in our own case. Something that not a lot of firms do, but if we've done a good job in our depositions, that's something we actually take advantage of at trial. But again, the overwhelming majority of cases, 90+%, never get to trial. And if we do get to trial, we want to be in the cat's bird seat to where we can be having fun and not so nervous. Now, our clients, of course, are scared of trial and worried about trial, and there's so much unpredictability with trial, even when we do our best. But we think we do a good job of getting our clients in the best possible positions to win at trial if that becomes necessary.